Good day, my name is Mark Malore. I'm an attorney here in Riverside, California. I've got a number of contractors and homeowners in Quinta, California dealing with mechanics lien issues, so I thought it helpful to put together a quick short video on some of the issues you need to consider when dealing with mechanics lien, whether a homeowner or a contractor. The first thing you need to consider and take a look at is, are you working on a commercial project or a home project for a homeowner? If you're working on someone's home, then you're defined as a work of home improvement, and in that particular case there's a number of contractual requirements that you've got to comply with as a contractor or as a homeowner accepting a contractor's contract with you. They've got to comply with a number of provisions in the Business and Professions Code. So you want to make sure that you're in compliance with that first. There are some penalties if you're not in compliance. The next thing we look at is, if you're not in direct contractual relationship with the owner, then you have to file what's called a 20-day preliminary notice. Whether you're a material man or a subcontractor to the general contractor in a project, you've got to file a 20-day before you can get the right to record a mechanics lien against the property. Now, if you're a homeowner and you receive a 20-day preliminary notice, it's nothing to be worried about. It's just to inform you that that person is working on your project, is supplying materials or doing some subcontracting work for your project, and they expect to get paid, and they're putting you on notice that they're on your property doing work. Nothing to be worried about. But that 20-day preliminary notice is a prerequisite to recording a mechanics lien against your property for being unpaid. So what do we have to do? Well, with the 20-day preliminary notice, it's got to be sent to you, certified mail, return receipt requested, to the homeowner, the lender on the project, if any, and the general contractor. As long as it's sent within 20 days of the first work, it will encompass all the work. If it's not sent within that period of time, it's got to be sent, it will only encompass 20 days back from the time it's sent to work within that 20-day period. Any work prior to that time is not covered under the mechanics lien later on. Now, assuming the contractor is in direct contractual privity with the owner, they don't have to file a 20-day preliminary notice, or they're not in direct contractual privity and they filed a 20-day preliminary notice. The next step, if you're not getting paid or the contractor is attempting to assert its right to payment, is the recording of mechanics lien. It's recorded in the county recorder's office. It attaches to the property, and that's got to be recorded within 90 days of the contractor's last work on the project. So if they've left the project for 6 months and then record a mechanics lien, it's invalid, and you can have it expunged from the county recorder's record. Assuming that's done, then understand there's another time frame that comes after that, and that's another 90-day period the contractor has with which to file a lawsuit to do what we call foreclose on that mechanics lien. If the contractor fails to file a lawsuit within that 90-day period after recording, then they waive the right to the mechanics lien. The mechanics lien is no longer valid, and you can have it expunged from the record as well. So understand there's some strict liability in terms of time frames in being able to perfect your mechanics lien rights. If you're a homeowner, receiving a 20-day preliminary notice or mechanics lien is not the end-all be-all, and there's things to do and take a look at that can still help protect you in that particular circumstance. If you have facts or situations you're facing, you'd like to discuss those with me, feel free to call and make an appointment. I'd be happy to go over those with you.